All right, I just want to start, and I had to write this down to make sure I get it all. But I want to start by, well, first expressing my gratitude to Kevin and the Horizon staff, to Bia and Shakruna, for the ways in which, they've now both platformed me. We'll see how that goes. But I also really want to express and embody gratitude for all the traditions, Native and Indigenous cultures, and all the communities and individuals who have developed this knowledge and relationships with sacred substances, because those are the beings who have been subjected to and have subjected themselves and endured criminal risk and injustice, prejudice, discrimination, and violence for us all to be here having these conversations and being part of this movement right now. And so I just think that's a really important thing to note. So with that privilege as our framework, I'm here to talk, oh good, and I can look there. I'm here to talk about the legality of religious use of psychedelics, or really any controlled substance, but the conference is called Psychedelics, so in the United States. And as Kevin said, we have a particularly unique system in the United States where religious freedom is protected in this way. And we're going to get into the nitty-gritty. I'm Allison Hoots. I'm an attorney, just not your attorney, yet. Actually, I am some of your attorneys, but I won't look at you now. Please note that no information provided here today constitutes legal advice, and this communication does not create an attorney-client privilege, and all information is for general educational purposes. Do not rely or act on the basis of the information provided on this presentation. It is necessary to seek qualified legal counsel specific to any situation and jurisdiction. All right, through that. I'm Allison Hoots. I'm an attorney. Well done, Bia. I advise in a ton of legal areas I won't bore you with right now. I'm also president of a nonprofit association of churches that's dedicated to protecting and advancing the safe, legal, ethical, and sincere ceremonial use of sacraments in the United States. We are a membership organization, and it's an incredible effort. I also work on policy for New Yorkers for mental health alternatives. Yes, New York. And I'm also on the Council for Protection of Sacred Plants at Shakruna, and I was the lead, I guess I am the lead author of the Guide to RIFRA and Best Practices for Psychedelic Plant Medicine Churches. And if this is interesting to you at all, you can dive into the dense 80 pages that is free to download off the website. So we have this right, the right to religious exercise. And that sounds so simple, but it really breaks down into quite a bit of information and analysis. This right is both at federal and state level. We've got constitutional guarantees, such as in the First Amendment, and then the state constitutions, which have their own right to religious exercise, often written differently than the federal law, which is an interesting analysis. But we're looking at the First Amendment here, and it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. But once we have the law, as I said, there's a lot in there. So how is it applied? What does that mean? It's a great question. I have a few answers. So when you apply a law, particularly in protecting a right, there are different standards of review. And so there's 3 ones often applied, and they are different levels of intensity, so to speak, and rational basis being the least strict, which is kind of funny because it seems rational. but I guess maybe that's more for the courts to decide what that means. And then there's intermediate. And then finally, we have strict, the strict scrutiny. And this is usually how we look at a law or an action by government if it affects a right or another issue, right? But for a long time, the right to religious exercise was protected pretty thoroughly. And then in 1990, in a case called Employment Division v. Smith, it held that where a law that is applied is written such that it is generally applicable, which means it doesn't target the right explicitly, but it has an incidental effect. So it didn't mean to. Then we don't have to apply strict scrutiny. In that case, and in this case, in Smith, they said, you know what, we're actually going to apply intermediate scrutiny. And that actually gave the government a ton of leeway. So in that case, the claimants, who actually worked at a drug rehab center, and they were natives, who had participated in a peyote ceremony the weekend before as part of their spiritual practice with their community. They had a drug test and tested positive for mescaline. They were fired from their job, and they were denied unemployment benefits because they were fired for cause. So they fought that. And the Supreme Court said, nope, the Controlled Substances Act, which you violated, was generally applicable. We didn't target your religious practice, so we're going to apply intermediate scrutiny, and they lost. What was one of the most bipartisan acts of Congress was just 3 years later, which is rather swift for legislation, which I'm learning quite a bit about right now. The Religious Freedom Restoration Act was passed. And what this did was it restored strict scrutiny. And it said very explicitly that the government won't burden substantially a person's exercise of religion, even if the burden results from a rule of general applicability. And then it explains the strict scrutiny test, which we're going to get a little more into. But ultimately, what they're saying is when the law is in furtherance of a compelling government interest and is the least restrictive way of doing it, then we can burden the religious exercise because we have a good reason for it. And what RIFRA does, yes, we call it RIFRA because it's cuter. It allows persons and corporations, yes, corporations, look at Hobby Lobby, who use, well, in this case, who use psychedelic, Hobby Lobby did not use the sacrament, who use psychedelic sacraments or controlled substance, that is a sacrament, to make a claim, to say, you know, nothing has happened to me yet, but I am burdened, and so I'm claiming in court, or when there is a criminal charge against them, to defend themselves in their religious exercise as an affirmative defense. Yes, I did it, but it was for this reason of religious exercise. And one of the things I love the most is that RIFRA was enacted specifically to protect sacramental use, sacramental ceremony. And if you look at the congressional reports from the Senate and the House of Representatives, they wrote when they enacted RIFRA that they had designed it to protect the ability of the religious minorities to practice their faiths. So, post-RIFRA, 1993, most of these controlled substances are still illegal. And the Controlled Substances Act is federal. There are state analogs. We now have some very exciting things happening in Colorado and Oregon and other states too. But ultimately, what the federal RIFRA, and I won't get too much into this, but basically there are state RIFRAs, which we call mini RIFRAs, because that is also very cute. They require that if a federal actor, federal law, or state actor, state law, does substantially burden of religious exercise, then strict scrutiny is applied, which is pretty incredible. Okay, so what's strict scrutiny? Here's how we break it down. There's a substantial burden by act or law. There was exercise of religion, and religion is a big word. There was sincerity in the religious exercise. So if you can show that, then the burden shifts to the government, and they have to say, yes, but we had this compelling government interest, and we did it with the least restrictive means of accomplishing the satisfaction of those interests. And then you have the opportunity to show how the government is wrong, but that's how that works. So we're gonna go through each part of the test, because each part of the test has its nuances, is done differently in each circuit, just to drive you all crazy and to make my slides really long. So what's a substantial burden by the government on religious exercise? There's two views, and sometimes they don't actually apply the ones they say they're going to. But there's the minority view, which is the stricter view, and I want to thank Matt Zorn for pointing this out to me a long time ago. But there's the centrality analysis, which is my favorite to go with, because why not, explain it in a way that really shows how important it is to you, because I believe that is the case with most of the religious practices with a sacrament. And what it says is you have a forced choice. Either you engage in your religious exercise or you comply with the law. You are compelled. And it can't just be that the exercise is significant. It has to be beyond that. It has to be an essential part of your belief. And so the circuits that do employ this minority test are the 3rd, 4th, 9th, and DC. You can Google to see if you're in it. And then there's a majority view, which is a lesser burden to say, well, it's a direct restraint on my religious exercise. My use of this controlled substance as a sacrament is religiously motivated, and it's significant, but not compelled. And the circuits that use this is the 1st, 2nd, 5th, 6th, 7th, 8th, 10th, and 11th. Yet the application of this is inconsistent. And I really do think it's because of the stigma of controlled substances, the drug war. So where there were some states that used the majority view, they actually referenced the minority view in their application. So interestingly, when RLUIPA, another cute one, Religious Land Use and Institutionalized Persons Act, passed in 2000, defined religious exercise, they explicitly said whether or not compelled by or central to a system of religious beliefs, which is interesting to consider that the federal government almost is giving the minority view a little kick and saying, we didn't mean that. It should be more inclusive. So I appreciated RLUIPA's definition, but we still remain in this inconsistency of circuits with this definition. What is religion? I'm a lawyer, I don't know. Neither do the courts, really. But I'm gonna tell you how they've defined it in the past. So Yoder in 1972, which technically was the strict scrutiny example that was reinstated by RIFRA, which was an Amish community. What the court recognized was their deep religious conviction that they were an organized group and that all of these beliefs were intimately related to their daily lives. So it's this comprehensiveness of their beliefs. A belief is religious according to Myers, which was a very helpful test that a lot of people reference, when it contains 1, ultimate ideas, 2, metaphysical beliefs, 3, moral or ethical systems, 4, comprehensiveness of beliefs, and 5, accoutrement of religion. Yeah. The good news is they said you don't have to hit all of these, but that it's just that you have to minimally satisfy these criteria. Okay, what is accoutrement of religion? So they gave some examples, as you see here. Founders, prophets, teachers, writings, gathering places, a keeper of knowledge, ceremony and rituals, structure, holidays, diet, appearance or clothing, proselytizing. One thing I always note is how aligned with Judeo-Christian concepts these are. And where we are meant to protect the religious minority, I wish there was more inclusion of criteria that addresses that. I know a lot of Native communities pass down things through words. There is no writing. A lot of communities don't have a leader. But fortunately, we don't have to hit all of those. Okay. And then interestingly, most recently in 2024, I really like this definition. This was in the Safe House case, which didn't actually turn out great for Safe House, but the definition was nice. Religion addresses fundamental and ultimate questions having to do with deep and imponderable matters. That there's a belief system as opposed to an isolated teaching. It's comprehensive, again, and that there's a presence of certain formal and external signs, aka accoutrement, right? All right, so we're not going to get too into this, but this is the IRS's definition of a church. Again, lots of Judeo-Christian concepts and practices here. Oh, I like this one. This is, what is religious activity? Sort of what is religious exercise? And in Safe House, they noted, sort of the issue of commercialization, whether it was secular, which again is like now just the inverse of religion, so we're back to the previous slides. And what was the one I really liked? How it holds itself out. So what are you saying publicly or to your congregants, co-religionists, and the aspects of prayer and worship? What is not religious? Now we're coming at it from the other side. In one case, it actually says, this is not religious. And so these are some of them and then pulled from some other locations, but standards on matters of conduct, philosophy or way of life. I think they actually said yoga is not religion in one place. Anything that's purely personal, political, secular. Oh, here we go. Veganism, not religion. Although I can imagine that would be a belief, part of a religion. Very explicitly says in the IRS criteria that there must be a community for religion. Even though the statute in RIFRA says it's for the individual. So I thought that was really interesting, but I guess now we're looking at more of what is a church or religious community. And lack of ceremony, which is part of the sincerity analysis. But what's interesting is that in 2014, I'm not going to get into the details of Hobby Lobby, you can look that up if you're not familiar with it, but in that case, the US Supreme Court said, it is not for us to say that the religious beliefs of the claimant or defendant are mistaken or insubstantial. Instead, their narrow function is to determine if the line drawn reflects an honest conviction. So suddenly they abandoned the religion analysis because I think they got a little flummoxed. And they said, we're going to focus on sincerity and almost like a sniff test, can we tell that you have conviction in your religious beliefs? And so how do you prove conviction? Well, they had some ideas. And in 2006, the Supreme Court said, okay, so here's what we think would demonstrate a lack of sincerity. Ad hoc beliefs. Well, what's that mean? I took Latin, thank goodness, but I'll tell you it means to this. And what that means is You're saying it to get around the law. So again, sort of a sniff test. But they also said what shows a lack of sincerity is whether there is such a quantity of the controlled substance it can't just be for the religious use, that there's evidence of commerce, that there is a lack of ceremony or ritual, and other illegal substances, because in this case, the person who claimed that cannabis was their religious exercise was buying cocaine from the same source, and the court thought that didn't look very religious. That was their opinion. I think some people have had very religious experiences on cocaine, but all right. So what are the compelling interests of the government that allows them to have the Controlled Substances Act and regulate us in this way? Well, they say there is a risk to us in taking these substances. And they also say that they're worried about these substances, if they are intended to be used for religious purposes, them being used for non-religious purposes. So actually, it's an interesting point that they make there, which is that they're okay with it being used for religious purpose. They just don't want the other recreational purpose. And I just want to at this point say that what can I say, appreciate all of the pathways, but we're going to be talking about how the government is very protective of this right. So when they analyze whether you are allowed to basically get around the Controlled Substances Act and to use that substance for religious purposes, it's a very individualized analysis. It is not, well, you are able to use ayahuasca, and so now all of you can. Instead, it's a one-by-one exemption process. And so they look with particularity whether they're going to grant you an exemption. And you need to show how it would create particular harms to you. So in 2006, one community succeeded. The UDV, whose sacrament was seized and there were threats of prosecution, was able to demonstrate substantial burden, and they were granted an exemption. And they said it was clear that, wait, can I go back? Oh, so what I want to go back to here. So really quickly, what they did in the cases to show that they minimized the government interests were the following. For minimizing risk to participants, you have to be able to show scientific evidence of safety, that you do screening for contraindications of health conditions and substances, and also to make sure that someone is not there for non-religious purposes. Which I can't imagine how you figure that out exactly, but and that if you are preventing diversion, or at least minimizing the risk of diversion, that again, everyone says we're here for the religious purposes, that you securely store your sacrament, that you keep very, very clear records of when you get your sacrament and when you use it, and that only certain people have access. Okay, so they were able to show that in the UDV case. They said the evidence on the health risks were equally balanced, and that they were able to show that they had mechanisms in place to minimize the risk of diversion. And the government failed to demonstrate the compelling interest of applying the controlled substances and preventing the UDV from engaging in their religious exercise with ayahuasca. Yeah, that's a pretty amazing case because it's sort of the foundation of religious use of sacrament today. And so 3 years later, in 2009, there was another exemption in the Ninth Circuit where the district court found the government had failed to show that they were justified in applying the Controlled Substances Act, granted an injunction, then there was an appeal, and the circuit court said, okay, you should narrow it a little bit, but ultimately it legalized another community to use ayahuasca in their ceremonies. I really loved this case in particular because they said that we need to see studies about the health of your community. And so they did a study on their community, and they showed that their community members were healthier than the general population. And they also said, well, there's no viable commercial market for ayahuasca, so it's probably fine in terms of diversion. And also, what was also funny about the UDV, and this is my favorite part, is the Supreme Court said, ayahuasca is such a terrible experience that it must be religious. There's nothing recreational about it. That's their conclusion. And they specifically said, but we would distinguish this from cannabis and meth. Unfortunately, showing a little bit of our racism, but here we are. So in the Ocentro case, which is the UDV case, the Supreme Court said the very reason Congress enacted RIFRA was to respond to protect sacramental use of a controlled substance. It was really just surprisingly incredible conclusion. So, what's the difference between spirituality and religion? I don't know. What is the bright line? If the individual is protected by RIFRA, when does an individual's spirituality become protectable? Can an individual get an exemption? We don't know. We are really at the threshold of these questions and figuring out what the courts are going to say. Back in 1965, they said religion is found sufficiently where beliefs are in the believer's own scheme of things religious and with conviction. That's another question. When is a communal use of a controlled substance religious? So very quickly, what's the tale of two DEA resolutions? SoulQuest and Church of Eagle and Condor. SoulQuest. Back in 2009, the DEA released guidance in response to the UDV decision in 2006 and says this is some temporary rules that still exist today that allows you to petition for an exemption. You don't have to go through the courts. We don't want to spend the money there. It's very expensive for us. Let's just have you apply to us and share all of your details of illegal activity, and we will let you know sometime in the future whether you might get an exemption. Don't worry about it. So they don't really explain how they're going to analyze it. They refer to RIFRA. They refer to Ocentro. But SoulQuest applied. They received no response. They sued. Then the DEA said, okay, wait, we were just about to give you a determination. How coincidental. And they then denied them. And in that letter, in the determination letter, they gave a whole slew of reasons why they thought they weren't engaged in religious activity. They said it didn't look like they were using a clear set of articulatable religious beliefs, that they referred to a religious manifesto that no participant had ever seen. Some people didn't know there was a religious activity happening. They talked about it as wellness, therapeutic, and for self-help, and it looked commercial. They also sourced from a soap company in Amsterdam the components, and that didn't look great for them. On the other hand, Church of Eagle and Condor, I'm sure some of you have heard, just received a settlement. Really exciting. So they filed a claim in 2022. They did not go through the petition process, right? But still the DEA is involved. And after really, really hard work, incredible team, legal team, religious community, they did settle just a couple weeks ago. There's no precedential value, which as a lawyer for me is disappointing. I don't get the juicy analysis of what is religion. But ultimately, we see a lot about the protocol that a DEA license would require, mostly with respect to securing the sacrament and record keeping. They did not really inquire into their religious beliefs, and from what I've heard from Joe Tafur and legal team, they almost refused to get into it referring to Hobby Lobby, saying, it's not really up to you. And this was a community that does not claim indigenous lineage or Judeo-Christian beliefs, which is also a first. So what are the current issues? There are a lot. A lot of people now think religious use is a way to get around the Controlled Substances Act. And honestly, I'm not surprised, because I think for a lot of people, there's something inherently spiritual about an altered state experience in a container that has a ritual and ceremony. No guarantees, but that is often where people land. And I think the problem is we're seeing some people distributing with no ceremony. And does that satisfy the risk to participants with screening and being there for their ceremony? And is there a risk of diversion? It's a really interesting question. Maybe that's their belief, but they're going to have to explain those parts. Churches that are saying we're legal to people when technically they are defensible. Misinformation about sacraments. Informed consent post-2020 should be very explicit. Here's our religious beliefs. This is what's in our sacrament. Here's what a ceremony looks like. Here are the risks. There was a great presentation yesterday about that. People need to make informed decisions. And we are unable because of the law. The law has made riskier a lot of these activities ultimately. Can you call for emergency services? A lot of people are afraid of professional criminal risks. Can a medical professional do the screening? They're afraid. They may not want to. Is there continuity of care where you can go to your therapist and say, I am having a hard time after my ayahuasca ceremony. Can I talk about it? And then I have a whole rant about the DEA petition guidance, but I think that I am eternally naively optimistic, I tell people, but I really hope that they are ready to create a very clear process for that. There's also a lot of abuses of power. We see that anywhere there's positional power. Doctor and patient, therapist and patient, teacher, student, in a lot of places. Clergy, congregant. So how do we fix that? In an illegal underground framework, a lot of people are not just ashamed because of the illegality, but also the abuse that they suffered. So how can we bring it up? How can we normalize it? We also need to work on a code of conduct and ethics that we can come to collaboratively and is based contextually on the religious beliefs that are particularized, not one size fits all often. And so I really like to see instances of collective responsibility and support for leaders and communities. And even nonprofit structures with a board can be helpful so that a facilitator, religious practitioner, doesn't have access to funds infinitely. So there is some kind of ethical procedure for receiving donations and not just receiving a very large donation in a suggestible state post-ceremony. So in my ideal world, what does it look like? A delineation between what is medical and recreational, personal, and religious use. A clear definition of religion, or leave it alone. But it needs to be broad enough that it's inclusive of the minority, but not meaningless. And also, what does modern religion look like? What do modern communities look like? We are living in a different world now. Sometimes your Zoom meeting is your community. And what is spiritual significance and safe sourcing when you can't access these substances? And how can we make those safer? I would love to see more continuity of care, opportunities for doctors, therapists, other professionals to be involved in the process without risk. honesty with your family and friends and doctors for external support, accountability for these leaders and their communities, and more eldership and mentorship opportunities so that people can actually learn how to hold this space and container, and a reasonable petition process.